So to get things started, I'd like to hand over to our first speaker, the VP and Managing Director of Telium and Meer, Mr. Lindsay McEwen.
Good afternoon, ladies and gentlemen, and welcome to the Telium and Digital Law UK webinar on what can you gain from this exciting piece of legislation, GDPR, which is a real testament to how much interest there is around this subject matter, is the fact that over 350 people subscribed to this webinar this morning. And it shows that this is an extremely exciting topic. Today, what we'd really like to do is talk about some practical information, some ABCs of what GDPR means to both organizations and individuals within those organizations. But really, what we want to do is talk about the fact that this is not an IT problem. It's not a problem with a legal team. It's a triumvirate of governance, technology, and insurance. And you'll be pleased to know that we haven't invited an insurance company along to this GDPR presentation and webinar. We do have myself, who I hope carries the bastion of technology, and also Peter Wright, the MD of Digital Law UK, who I'm assuming carries the bastion of governance. Today we're going to give you a view into both the legislation, the opportunities, and how technology can help you with GDPR. Without further ado, I'd like to hand things over to my colleague Peter Wright from Digital Law UK, to introduce our first subject and kick the session off. Peter, what is GDPR?
Thank you, Lindsay. Hello, everyone. So I was thinking of spending the first hour saying what is GDPR, and then realised that we haven't exactly got that long. So I'm going to give you a video whistle-stop tour through what is GDPR. GDPR is a European-wide, pan-European data protection regulation. This replaces the previous data protection directive issued by the European Union in 1995. So 20 years on, we are upgrading the law to reflect the digital world that we now find ourselves in. So if you think back to 1995, when the last set of laws came out, we had no smartphones, we had no tablets, we had no smart watches, we had no big data, we had no social media. Very, very different world. So therefore, this regulation attempts to try and bring some clarity and apply some rules in what almost has become the Wild West, really. So really, it is attempting on a pan-European basis to bring some clear clarity to this field. But big difference from the law 20 years ago is that this is a regulation, so it's not necessarily the case that countries have to enact their own data protection acts or legislation. So those in the UK will be familiar with our Data Protection Act from 1998, which is often quoted when you're handing over personal data. That's no longer going to be the case. It's not going to be the Data Protection Act 1998. We're actually in the UK, for example, going to be referring to a new Data Protection Act 2018, which will enact GDPR into the law of the United Kingdom of Great Britain and Northern Ireland. And the reason we're doing that specifically is because, of course, the UK is leaving the European Union. So we're ensuring there will be a position of regulatory equivalence between the UK and the European Union as of February 2019, when the UK will be leaving the EU. So therefore, we'll be dealing with GDPR as it is written into UK law after the UK leaves the EU. There are certain principles that are being carried over. So to a certain extent, you can see GDPR as a significant upgrade of our existing data protection laws. There are a lot of existing rights in there that are being extended in effect. So they're just being it's an entirely consistent evolution of the existing law. So, for example, personal data, the definition of personal data is largely the same. Personal data is anything that allows you to identify an individual. So, for example, a name, an address, a date of birth, a national insurance number, a photograph, video footage, video recording, an audio recording, so a voicemail or a recorded phone call. That all accounts as personal data, as does, say, a copy of someone's passport or driving license. One addition there is that, for example, an IP address will now be personal data under the new legislation. So therefore, if you've got a set of data and the unique identifier in there is an IP address, that will mean we're talking about personal data. The key thing to remember is that GDPR and data protection legislation as a whole is always concerned about personal data. So if you have a data set or you have a set of information that does not contain any personal data, then in effect GDPR falls away. So it might be commercial data, it might be very confidential, it could be commercially sensitive, but if there's no personal data in there, then GDPR will not apply. Furthermore, existing principles around data retention will continue. So, for example, data should only be obtained for the purpose for which it is required. It should only be kept for the purpose for which it is required, and then it should not be kept for any longer than is necessary. That's the law as it is at the moment, and that will continue to be the case under GDPR. So if, for example, you're retaining documents or information for a far longer period than they are required, then you're going to be in a problem. So we've found that sometimes we go into some firms and organizations helping them with their data protection compliance, and we've found that they've, for example, had email servers for 20 years that have never been reviewed, and there could be information that's been kept on those servers for far longer than would have, for example, been necessary. Another significant change is also that people may be used to data controllers having to be registered with the Information Commissioner in the UK and indeed registered with the regulators around Europe. That right will happily fall away under GDPR, but instead you will have to register the details of your data protection officer, and you will have to have a mandatory data protection officer if you have more than 250 staff, or, and this is the key thing, or you're handling a large volume of personal data, or you're handling a lot of sensitive data. So, for example, healthcare professionals, law firms, banks, accounting may find themselves having to appoint a mandatory DPO because of the sensitive types of data that they will be handling. So that's sort of a brief introduction really into GDPR. So let's now start going through into some specific areas. I'm sure you will all have heard a lot about the penalties under GDPR. Under the existing legislation, you can only be fined in the UK up to £500,000 under our Data Protection Act, £500,000. Even then, the most that's ever been levied in a fine is £400,000. Carphone Warehouse were fined £400,000 just a few weeks ago by the Information Commissioner in January 2018. Before that, the equal record high fine was given to TalkTalk. However, under GDPR, you can be fined up to €20 million or 4% of global turnover, whichever is greater. That applies to all public sector companies. If you're a public body, it would be €10 million or 2% of global turnover. So it's significantly higher fines, but there's an awful lot of snake oil salesmen at that moment saying, look, you're going to get fined €10 million for sending an email to the wrong recipient. It's not really quite that bad. Enforcement will remain on a proportionate and reasonable basis by the regulators, but obviously if the regulator investigates and finds that you've totally ignored GDPR and its principles, then they're going to be minded to fine a significantly greater amount than they otherwise would. So the penalties, while they may seem high as well, if you think about it in relation to, say, financial issues, the Financial Conduct Authority in the UK can levy fines of that sort of size. So really it's just making the fines proportionate in comparison with the fines that you can receive for other compliance issues. So let's go on from there. Consent is a tricky area. I know a lot of people are concerned with this, particularly from a sort of direct marketing and sales perspective. GDPR talks about specific informed consent, and it talks about that as being one of the 6 lawful bases for processing. In effect, GDPR still talks about the data processors and data controllers. So controllers are the people that retain data. Processors are those that receive the data, do something with it, and then return it. What it comes down to is that specific informed consent is one of the 6 bases upon which data can be lawfully processed. Those other bases are in performance of a contract. So if you have a contract that says you'll be processing this data, that is going to be sufficient. If you are complying with a legal obligation, so if there is an act out there that says this organisation must process this data for these specific purposes, then that will be okay. It could be in the vital interests of the data subject. So if, for example, we're talking about healthcare or law enforcement, you could argue that that's a vital interest. It could also be under the next issue, which is public interest for the processing of data. But you can imagine that, for example, a marketing email, you can't say that's either a vital interest or a public interest. And the final reason that you can use for processing data is legitimate interest. And when it comes to legitimate interest, that could be whereby someone comes to an organisation and says, I would like to buy this service or this product. Well, it's going to be in the legitimate interests of that person for their data to be processed so they can receive the product or service that they're wanting to have. So those are the 6 bases. Consent is where it talks about specific informed consent, whereby that has to be given by data subject so that their data can then be processed if those other 5 issues can't be satisfied. So if, for example, we have someone registering for a newsletter online, you would get specific informed consent. But at the moment, for example, you might just tick one box whereby you accept terms and conditions after having entered your name and address and date of birth or another unique identifier. That will no longer be possible under GDPR. You will instead have to give specific informed consent for the specific purposes the data is going to be used for. So you might have to give a tick to say, yes, I'd like to receive a newsletter. Another tick to say, please tell me about your future products and services. Yet another tick to say, I'm going to share it with a third party. So from that, you can see that there's going to be potentially quite a few hoops that a data subject will have to jump through in order for their data to be processed. Furthermore, you can't induce someone to give that consent, otherwise it's not properly being given freely, it's not being given in an informed manner, it's not being given in an unambiguous manner. So you can't say, you have to give consent, otherwise we're not going to give you access to the website or product. You can't say, please click here to give your consent and we'll give you a £5 gift voucher for Marks & Spencer in return. You can't do things like that. Consent has to be freely given specifically for the specific task for which the data is going to be used for, and it has to be unambiguous. Consent can be a difficult issue. I know a lot of people, when it comes to direct marketing, have a lot of questions about that. That's all I'm going to say on it for now. But if anyone does have any questions, then please do enter them online or contact me on social media. Moving on from there, breach notification. Reporting of data protection breaches isn't entirely mandatory, in the way it isn't entirely mandatory now that all breaches are reported. However, you have to have regard to the interests of the data subject or data subjects whose data may have been breached. So if we're talking about a large volume or we're talking about very sensitive data that's been breached, then you're going to end up having to report that to the regulator. You have 72 hours to do that, which wasn't previously the case. Furthermore, that reporting to the regulator isn't just a matter of picking up the phone and saying, hello, we've had a breach. Unfortunately, you actually have to give them quite a bit of information. You have to say, who are the data subjects who've been affected? Is it, for example, your marketing list? Is it your staff? Is it a HR payroll or database that's been breached? Is it your customers? What's the cohort of data subjects? How have they been breached? What's at risk? How are you going to make sure it doesn't happen again? Are you liaising with the police? Are you liaising with other agencies? All of these sorts of things will have to be reported to the regulator. Now, it might be difficult to do that initially within 72 hours. You have to demonstrate to the regulator that you're thinking of all of these issues. The less information you give to the regulator when you notify them, the more likely the regulator will then go, oh, why weren't they able to confirm all this to us now? We'll have to keep an eye on this. So therefore, the likelihood of potential investigation and regulatory action afterwards will be commensurately greater for you if you haven't complied with giving as much information as you can within that 72 hours. So you've got to have a plan to deal with that. I'd also recommend testing it. I've heard of some organisations that have breach response plans in place and they've gone, we're fine, we have a great plan that works. And then when they've actually had a breach or they've tested it, they've suddenly found that the plan doesn't work because half the people in that plan have now resigned and moved on, or they've gone to other roles, and you suddenly find that there's no accountability and no responsibility taken under the plan. So have a plan, test it, make sure it works. So let's move on from there to data protection subject access requests. This is where a data subject can request to see all of the information that's held by an organization about them. There's a slight change on this. It's an existing right under existing data protection legislation. Under GDPR, the deadline will be reduced. It goes down from approximately 40 days down to approximately 30 days. And also, big change, organizations can no longer charge a fee for processing a subject access request. It's a common way at the moment that organizations will get out of having to reply to a subject access request because they'll turn around and say, you know what, we want to charge a fee, please send a check to this address or this PO box number, and then we'll respond to you, during which the deadline in which to respond is on hold until the fee is paid. And of course, an awful lot of people, indeed the vast majority, don't then pay for the request. So you can't unfortunately turn around and charge the fee anymore, so you have to reply. Anecdotally, I've spoken to compliance officers in a number of large organizations, and they're already noticing a significant increase in the volume of subject access requests they are facing, and in addition, they anticipate that increase will only exponentially continue to increase after 25th of May 2018 when GDPR comes in. The only way you can potentially not reply to a subject access request is if you can prove potentially to the regulator that the individual making the request is acting in a vexatious manner or an excessive manner by making a request or indeed a series of requests. But the onus would be on the organization, the controller or processor, to be able to prove that that is the case. So more often than not, you'll have to comply with it. So that's subject access requests. Let's now go on to the right to be forgotten. This is a right under GDPR, but it's also currently EU law following a court case a few years ago. The idea of the right to be forgotten is that individuals can request of organizations that their information is forgotten. This is already the case following some litigation with Google, whereby they had an individual who said, will you please stop referring to things from my past when people Google my name online. So Google had to remove the links to some articles about this individual, some news stories that were still online that had been there for the best part of 20 years. Now you'll be familiar with this if you're using Google from an IP address within the European Union. Sometimes you get to the end of your search results and it says, please note, these search results may have been affected by legislation in the European Union because they've had to remove certain links. GDPR takes that right and applies it to all organizations.
Peter, a quick question.
Yes.
You mentioned there quite deftly timing, and something, GDPR becomes applicable on the 25th of May. Mm-hmm. If an organization has a marketing database, an email list that they collated previous to the application of GDPR, does GDPR still stand, or do they have to create a new compliant list from the ground up?
That's a very, very good question. There's been some guidance from the European Commission or the Article 29 Working Party in Brussels on this. And they have said that it's not necessarily the case that the entirety of any existing records would have to be deleted on that day, because technically you might find that you no longer have the lawful reason upon which to process that data. You might not have the record of specific informed consent to go alongside that email address to allow you to carry on contacting that individual or individuals. But the onus will come on to the organization to have those records of specific informed consent if they are so required. So say, for example, you acquire a data set from a third party, and that provides you with, a few hundred or a few thousand email addresses. You as an organization would have to prove to the regulator that you have consent to use them. So if they've been sold to you and they don't have those records of specific informed consent with them, you might find yourself in difficulty proving to the regulator that you do have consent, or indeed any legal basis upon which to be processing that person's data and sending them a mail shot, for example. So it's kind of going to mean that in effect you'd have to start changing your practices from the 25th of May accordingly. As a result, and I don't know if this is the case for you, Lindsay, but I speak to a lot of people who are currently almost suffering an email barrage from organizations getting in touch and requesting consent so they can carry on emailing you after the 25th of May. The promotions tab on Google is just full of these things at the moment.
I've even heard of a very well-known United Kingdom pub chain,
Yes.
Who decided that the way forward is to delete every single contact they have in any marketable database,
yes.
And rebuild it from the 26th of May onwards,
yes.
to ensure that all consent has been given.
Indeed. They've actually turned around, I think, and they said they're going to delete the several million emails that they've got, and they're probably just going to mark it in a different way in future, because I think they've looked at the cost-benefit analysis of getting specific informed consent in future, both from their new subscribers as well as potentially getting hold of that consent for existing users. And they just found it was such a headache, and so onerous to do and so expensive to put in place that they went, what's the actual benefit for us in doing this? Shall we use our marketing resources in another way?
And it's a really valid point. And when we finish talking about GDPR, it's going to be one of the things that you and I are going to cover under the opportunities. And what can people do to manage both direct marketing, digital communication, and that whole plethora of digital comms. So moving on to data portability, which is a very interesting part of a right under GDPR.
Yes, so you are now entitled to be able to take data from one source to another. So you're used to doing this, for example, with, say, moving a bank account from one bank to another, and this is, in effect, enshrining that right in law. But it's saying that you now have the right to request data from any source where it's being held or processed or controlled, and to then say, right, this is now going to be something that we can take and use elsewhere. So you've got the freedom of choice, the freedom to move elsewhere. Now, at the moment, you might find that when you try and do this, you might receive the data in an unhelpful format, particularly if it's sent to you in hard copy on several reams of A4 paper, and you've then got to sit there and go through manual data entry to put it into the format you need. So they basically have to send you in the medium, send it to you in an appropriate medium. So, for example, they can't send it to you using a encrypted CD-ROM drive when you don't actually have an encrypted CD-ROM drive. It's got to be in a format that's helpful. So, for example, it can't be, if you want it in Word and it's sent to you in Word Perfect, that wouldn't be helpful. And it's got to be usable, it's got to be appropriate, it's got to be in the format that will help you to use it in the purpose that you need it for. So the fact that you have that means that hopefully organisations can't use that as a way to stop you moving, which might sometimes be the case. Going on from that, the next bit I wanted to talk about was privacy by design. This is a key issue for all of those, particularly in the sort of tech development and IT sector. When it comes to new projects, new systems that are being developed for organizations, you have to consider data protection at the outset. You can't, so for example, start to build a new app or have a great new idea for a new system, run off and build it, and then suddenly retrospectively think about security and privacy. Instead, you need to do it at the outset, and the best way of demonstrating that to the regulator is by doing a privacy impact assessment. On the Information Commissioner's website, you can find there is a very helpful code of conduct which contains templates that you can use that will help you to put together a privacy impact assessment, and that will then ensure that you can make sure security is built in from the get-go, that you've got. Indeed, this can actually lead to savings, don't forget, because if you're then using the appropriate system from the outset, you aren't expensively trying to adapt something later on. So it can be, make sure it's secure from the outset, making sure that system architecture is appropriate. Furthermore, it allows organizations to be very transparent and then, for example, publish either the impact assessment or a redacted version of it on their websites, or certainly you can publish it as part of your compliance requirements. So you can say to third parties and users of your services, look, here's our compliance statement, and here are the appropriate privacy impact assessments for the systems you're going to use. It's also appropriate to think about doing this for some systems and projects that might already be up and running. So it might be worth doing it retrospectively for systems that might have already been operating for 5, 10 or 15 years to show that you have considered the privacy issues around those as well.
And that makes for a really interesting point, Peter. Building an architectural environment from the ground up is a luxury that very few businesses have unless they start on the 26th of May and form themselves as a business. There are a large plethora of businesses out there who have a huge amount of legacy systems sitting inside their organizations. How other than the privacy impact assessment, what sort of nuggets could you give organisations who are looking at a long-built architectural environment that they're going to have to think about how to retrofit privacy by design into 20-year-old balance systems within the financial services system, FMCG with large product SKUs that are sitting on systems that are 10 years old? What sort of advice would you give to businesses that are thinking about that?
I'd say it is worth doing the retrospective privacy impact assessment, and the key thing to do is to carry out some data mapping, find out where all the sources of data are. Are we looking at a single location in terms of servers, multiple locations? Are all those servers secure, encrypted? Are they all within the European Economic Area as GDPR specifies? If you can then answer those questions and you know how and where the data is, making sure that in terms of how data is going into that system and how it's coming out, that those methods are also secure. In particular, when it comes to the transfer, storage and retention of data, that's being done securely, and indeed that data is only being retained that needs to be retained. I know it's also a bit of an issue for organisations, particularly with legacy systems and older systems, that complying with a subject access request or complying with a request under the right to be forgotten can be difficult because, for example, you might not have the hard deletion facility to comply with a right to be forgotten request. It might be difficult and time-consuming to review a data set to comply with a right to be forgotten request because, let's face it, there could be some data that has to be deleted and other things that do have to be retained for very specific purposes. Likewise with a subject access request, that can be a large exercise to actually review and ensure only the right data is then being disclosed. So sometimes where you're using older, wider systems, it's then sometimes worth having something alongside it that can act as a document management system that allows for the quick, speedy review of information, sometimes via artificial intelligence, and that will then allow for you to be able to redact documentation where you need to ensure you can quickly and easily comply with the needs of GDPR, but without necessarily having to root and branch replace a whole system if you've got the right systems working alongside it.
And it's interesting because there's quite a few questions around the timing of the implementation of this regulation. And a really interesting question that I've been asked a million of times by vendors and also by customers is, what do we have to do by when? And let me frame what I mean by that. On the 26th of May, do we have to have a full and compliant GDPR compliant environment existing within any one of our outreach programs, any one of our data marketing? Or do we just have to prove to the ICO that we've taken steps to become compliant? I guess the question is, will the drawbridge come down on the 26th? Or is there going to be a cheeky little side entrance that we can use for a period of time until our organisation catches up with the regulation in place?
I think it's of those two options, it's definitely the second, really. So certainly the regulator is going to be looking for evidence that you are aware of GDPR and you're doing your level best to try and comply with it. But through the whole regulation, there is the language of it being proportionate and reasonable in terms of how you're complying. So the regulator is going to be mindful of the fact that you might not have massive resources, you might not have a massive budget that you can throw at your compliance, but they're just looking for you to demonstrate that you're doing all that you can be reasonably be expected to do. So if, for example, you've got a compliance plan, you might have had a gap analysis done, and if you're working towards compliance, even if you are not fully compliant by 26th of January, 26th of May, at least if you can demonstrate you're working towards it with your best efforts, and even if the worst happens at that point and the regulator starts asking, well, why weren't you compliant? You can say, look, we were doing all we reasonably could. This is the budget we'd given to it. We'd started preparing a long time ago. We aren't quite there, but we've done all we can reasonably be expected to do. And don't forget, months and years past the 26th of May, that's still going to be the case. So even if you say, look, we did all that we thought we could to comply with GDPR and we still had a breach, we were still hacked, we still had a break-in and someone took our IT equipment, there's always going to be breaches that will happen even with your best efforts. You just have to demonstrate that you are doing and acting in a reasonable way, and that will mean that the regulator is going to take a much better view. Don't forget, I was talking earlier on about those fines. And the reasons why Carphone Warehouse and TalkTalk ended up getting the fines that they did was because the regulator looked and thought, given your size, given your resources, given the vast amount of personal data you're handling, and given the prompting in certain instances from their own customers in terms of where problems were coming up, they really should have acted more speedily. They should have given more seriousness, treated these issues with more seriousness, and that's why ultimately they've ended up facing the fines and the regulatory action that they have, because they weren't felt to be acting in that reasonable and proportionate manner.
Moving on to the next subject matter, which is always an interesting one to hear the lawyer say to you, we're in this together. I'm sure in a court. That's never something I ever want to hear from you. But we make a really valid point. It's not just about getting your lawyers all hocked up. What other parts of the business do people need to think about as they're looking towards a GDPR impact?
I think the key thing here is to make sure that when you hear the GDPR or the word data protection, you don't sort of think, oh, well, this is like the IT department's problem. Fun enough, a few days ago, I was in a training session, and there was about 80-odd people in there, and there was one table full of this organisation's IT staff, and everyone sort of kept on looking over to them as though it was something they were working on, it was their issue. And that is no longer the case. You can't just point at the IT people, and you can't even just point at the compliance people and say, well, it's your problem to deal with. Because if there is one of those large fines that does get applied to the organisation, it's actually going to be the whole organisation that has to deal with that. So it's a matter for management, it's a matter for boards, it's a matter for chief executives and chief operating officers to be aware of, it's a matter that financial directors need to be aware of and budgeting appropriately. It's something that shareholders are going to want to know about, because let's face it could be their dividend that ends up being affected. The whole organisation needs to be asking questions about this, and you all need to be working together, because don't forget, as we said at the top of this webinar, this isn't just something where you can say, right, I've got a great technical solution in place, I don't need anything else. Ideally, you need to have good governance, good procedures, policies in place, the right rules, the right plans in place to deal with things if the worst happens, and be testing those. So you need to have that. You need to have the right technology solutions to help you with data storage and transfer, and probably the right insurance. But you can't just rely on one of those. So it's across the whole organisation. You need to be able to demonstrate compliance, not just by saying, oh yeah, we've got this tech solution that IT do and that's it, and we're absolving all responsibility. You need to be able to demonstrate compliance across the whole organisation.
It does feel like an opportunity for organisations to put together a GDPR council. Being British, we don't like to operate outside of our own silos. So I think the key to success in any organisation for compliance with this particular piece of legislation is togetherness. And this concept of not just having a DPO or a DPA being responsible for the entire problem, but it being a collaboration between technology, governance, HR, staff and process, because as I've said a million times before, we can have the finest privacy by design, the greatest protection and breach notification systems, but and this never happens because we never hear about it in the newspaper. What happens when the CMO leaves his laptop on the 9:15 from Waterloo to Ascot and bot? So the reality of it is it's an industry and organisational wide movement towards a piece of legislation which is putting iron cuffs on the DPA.
It is, and it's also a matter of actually thinking about this in a proactive way and putting your redundancies in place. So we talked about the 72-hour breach response. What if that breach, and that's 72 hours from the date of knowledge, what if your date of knowledge is 6 p.m. on a Friday evening and it's a bank holiday? The 72 hours continues to tick by. You can't turn around and go, oh, it's the DPO's fault, he needs to be told about it because he has to deal with the response, but well, what about if he's gone away for the weekend? Or what if he's in the pub and you can't drag him out at that point? You have to make sure you've got redundancies in place. You can't just go, oh, so-and-so's not in today, we'll have to leave it till tomorrow. So absolutely, you need to have a compliance group working on this, so that even if one or two people are away or out of the office or indisposed or in a meeting, then someone else can pick it up and be responsible and start moving things forward. So it's no longer appropriate just to be able to go, well, it's the DPO's problem, and then not give them the right resources or the right time or the right support. It does indeed have to be that proper collaborative effort across the whole organisation. You have to break out from the silos that you may have been working in.
So a lot of legislation that people have to comply with, a lot of things that people have to think about. So talk to me in your mind some of the opportunities that organisations can gain from complying with and getting involved in GDPR.
Well, I think one of the big benefits is that, I mean, we've all seen in the press so many stories about organisations suffering from cyber attacks, personal data being breached, people being affected by that, negative publicity, fines from regulators, loss of business, organisations folding as a result. You know, we see about these all the time. If you are paying attention to GDPR compliance, it at least allows you to start reducing some of the potential for hacks. You'll actually go through, identify some of the risks and the weak points, and start working towards reducing those risks and hopefully eradicating them. GDPR is all about demonstrating compliance to the regulator. So as well as actually having some plans in place, for example, your breach response plan, as well as having a team of people to work on compliance, they can then be ensuring that then if the worst does happen, you can respond quickly and effectively. You can look after your customers, you can look after your staff, you can look after the whole organisation to hopefully get through it in as good a shape as you can. But also it means that then, when, for example, you're asked by a third party or you're asked by a regulator, can you please tell us what you do with your data? Can you please tell us the standards you work to? You've already got the documentation available. You can say, here is our GDPR compliance statement. Here is the data protection privacy impact assessment for our main system. Here you go. Here is the transparency. The more that you've got that, it's actually incredibly useful, particularly if, for example, it might be where you're tendering for work, or it could be where you're entering into a big contract. If that due diligence is already there and together, either you certainly don't have to do it from scratch, or you might just have to amend it a little bit to reflect that current transaction. That's going to make life an awful lot easier. And then the reporting and the collaboration in terms of managing risk that GDPR encourages is just going to ensure that better communication, so people are aware of risks. And who knows, you might start talking about other things across the business too that will affect it. And that level of communication and awareness is proving to be invaluable, particularly as it becomes more and more essential for organisations to respond quickly and effectively to these sorts of issues.
That's some really interesting organizational opportunities internally as to how to put yourself forward as a trusted business that is compliant with this piece of legislation. I think to talk briefly about technology and how it impacts digital marketing and the impact of personalized messaging and personalized offering of goods and services, some of our customers have done some analysis as to, okay, so I'm introducing a much bigger granular level of consent. Is this going to scare people off? Are people going to be less comfortable at giving privacy data? And weirdly, we have a German publisher who's estimated that the amount of events that take place that they can track could drop by up to 80%. I've seen some salespeople waving their arms around in conferences talking about this being the death of direct and digital marketing. To me, I see it in a much more positive way. I see this as being the opportunity for organizations to look about how do they onboard people into their business. What does consent look like from a physical standpoint? When they're logging into a website and that website is asking for consent to communicate an offer to them, How are they building a technology response to that, instead of just complying with the regulation by having an extremely granular, horrifying page presented to them, which suggests that we're going to use data for a panoplia of different items. And I think that working between your technology team and your governance team, but more importantly, looking at the opportunity of how you present the consent stream, how you drive people on board, and what are we going to do with your personal data? How are we going to represent you as an individual within our organization? Because one of the bits within GDPR that I like the most, not only is it a complex word to pronounce, synonymization, that's not one to do at 2 o'clock in the morning. Synonymization is a really interesting thing for an organization like Telium, because we're all about taking the individual out of data. We're all about creating anonymous badges for people that we can circulate around the business to mean that only the relevant piece of data that is required by an application to communicate with that individual is passed through to them. You talk to, I guess, where am I going with this? It's a great opportunity for organizations to look at the process of how they speak to people. It's a great opportunity for looking at the language around how we're going to offer people specifically tailored products. And it's a great opportunity to look at your technology, because the last time I checked, there is no technology out there with a big, easy GDPR button on it, sadly. Organizations like Telium can help you build a universal data hub to control, monitor, and move the appropriate data around your business. But I think there's a real opportunity for organizations to kind of put a trusted kite mark on their brand by saying, you know what, we will curate, protect, and manage your data in a way that is both compliant with GDPR, but also compliant with modern digital marketing. Therefore, give us more data, give us more information, and we can provide you more appropriate goods, products, and services. I have a personal interest in this. My name's Lindsay. Most organizations make a probabilistic determination that I am, in fact, a girl. And it would be delightful for me to be able to provide personal data so that they could determine that I wasn't 70% a female, but 100% a male, and give me the right products, goods, and services based on, at a minimum, my gender, never mind how I interact with the brand and what I'm looking at. Do you think that this is an opportunity for organizations to really look at the science of this, or is it the death of direct digital marketing?
I think it's definitely an opportunity, because I think it allows us to reform digital marketing to a significant extent. I don't know about how a lot of our listeners today feel, but I very often find that I'm receiving a barrage of promotional emails every day, the majority of which I do not read or look at in any way, shape or form, because we just are fatigued with the volume of this. By complying with GDPR, I think it will actually allow people to engage better with their users and recipients of their communications. And it'll mean the lists and information that you do have will be of people who are engaged, who do want to hear about the products and services, rather than saying, well, actually, we've got all these millions of people, of which only perhaps 1 or 2% are actually engaging. An example of this would be, there's one website I registered with a couple of months ago, and you could tell that they'd built this platform with a view to complying with GDPR, because you registered and it had, rather than one tick box, there was about 5. So I was very clear on what I did and did not want to receive. And then after a few weeks, the emails changed from just the standard, here's our marketing email with today's products and offers, to instead saying, we have noticed you haven't opened up anything for the last couple of weeks. Are you still wanting to receive these? If we don't hear from you, if you don't log into the website within the next couple of weeks, or if you don't open up our emails, because let's face it, email analytics, you know if something's been opened or not. And they basically said, look, if we don't hear anything more from you, then we will assume that you don't want to receive it, and we'll say thank you very much, and we'll stop bothering you. which I think is great, because if you don't want to receive it, why should I have to continue to receive this and then have to go through a long unsubscribe process potentially? So that means that organisation is going to be left with a contact list of people that do want to receive the information rather than potentially those who don't, let alone the fact that then you get organisations that build up long databases of emails of people that have moved on, who are now working in different roles or organisations. And then it means that just the resources being wasted as you send away a communication that's never actually going to be opened. With regards to the anonymisation, pseudonymization point, that is an excellent point, because, as we said at the top of the discussion, GDPR only applies to personal data. If you can anonymise as much of that data as possible, or pseudonymise it, that will ensure that in fact you're able to say that, well, there's no actual personal data in this data set, therefore GDPR does not apply. So the more you can demonstrate that, the more that you can demonstrate that element of data hygiene with regards to how the data is being used, the better, to be perfectly honest. And systems that allow for the easy use of that technology will make compliance for organisations an awful lot more straightforward. And you're quite right as well, Lindsay, saying there's no easy way towards GDPR compliance here. You know, if it was possible to just go and buy one product that did everything for you, everyone would be doing it. And unfortunately, there isn't. There is no one single book, there's no one single webinar, there is no one single product that will do all of this for you. It's more about being aware of the issues and then making your procurement and your compliance dependent on the risks you've identified and how to deal with those. So, and that's because all organisations are different. GDPR is not prescriptive. It does not tell you specifically what consent will do and what consent won't. It just basically has a series of outcomes, a series of things it wants you to achieve, and it does not tell you how to achieve them, because it knows all organisations are different and operate in different ways. So it just basically says, this is how we want you to do it. This is what we want you to achieve. We are not going to tell you how to do it, because that's not for us to do. That's for you to work out and to make sure that you are then able to demonstrate compliance appropriately.
So a great opportunity for businesses to look at the science of how they gather data, interact with data, and make offerings. Because I do believe with you, I think there's far too much irrelevant email content out there, and those data cowboys that provide us huge lists that people successively spam is, I think, the death of a great communication channel in email. I think it provides a really relevant, I think I'm showing my age there, a relevant, interesting a communication channel, and by getting rid of the vast kind of spray and pray communication techniques and making them more appropriate and specific, I think will really give us a great opportunity. So moving on from the opportunity itself, let's talk about the benefits. We've talked a lot about fines. We've talked a lot about the opportunity. What sort of benefits do you think organisations can get out of a strong application of this legislation to their business?
I think if you're making reasonable efforts to comply, you can come out on the other side of this process as a much better run, better drilled organisation with significant savings that can take place, a significantly greater understanding of an organisation's systems, and indeed you can actually cut down a lot on the level of resources and budget that's being used in certain regards. So what do I mean by all of that? Well, let's take a look. First of all, we've talked about breach responses, and we've talked about having plans and things in place. If you know what's going to happen if the worst thing happens, if you've got a plan to deal with it, if you find that you've been hacked, if you have the plans to deal with a large volume of subject access requests or requests under the right to be forgotten, if you know how to handle all of your marketing data to get a lot out of it, that's got to be of benefit to your organisation. You know, we all want organisations to be more productive. We want to be able to get more bang for our buck, and I think there's some good general outcomes from complying with GDPR that mean that you will be able to do that. You will be regularly testing your plans. You'll know that they're up to date. You'll know that they work. And that's got to help, even if it means that then if the worst does happen, your commensurate costs in dealing with a breach will be less and reduced. Second thing that we could look at is the fact that under GDPR, you can nominate a single regulator from within Europe or the European Economic Area, to deal with your compliance. So at the moment, if you're a multinational, you're operating in Germany, France, and the UK, you're having to liaise with CNIL in France, you're dealing with the ICO, you could be dealing with any one of the number of state regulators in Germany. And that can be a bit of a headache, because at the moment they've all got slightly different versions of the data protection legislation that they're using. There will continue to be regional variation of GDPR, because it still contains 99 articles and 173 recitals and a number of derogations that mean that it can be enacted in slightly different ways in each country, so there will still end up being variation across the single market. And rather than having to therefore liaise with all these different regulators, instead you can nominate one and say, you're going to deal with me for all of the work that we do across Europe. So you can just say, right, I'm going to work with the Spanish regulator or the Dutch regulator or the ICO in the UK, and that will be sufficient for all of your European regulation. That's got to be of a benefit compared to the current position and the intensiveness of that. Another area where I think there's going to be a saving is that in order to move data outside of the European Economic Area, outside of the EEA, you'd have to do it either by sending it to the US under the EU-US Privacy Shield or by using binding corporate rules or model contract clauses. Now, the majority of organisations, that's probably going to mean using the model contract clauses that are specified by the regulators. And that means reviewing your contracts. And if you're going to review your contracts, that can be a useful operation too. You can make sure that any of those contracts are still in force. You know, some contracts can be for a set period, and sometimes organisations simply miss the fact that a contract might have expired, and both two or three bodies might carry on the same course of dealing, but they're actually doing this under a contract that's expired. If you know your contract terms and you've catered for them, that's going to help. It also means you're checking that those contracts themselves comply properly with GDPR. In other respects, in terms of how data is being handled and shared and retained and destroyed and transferred, that whole process of just acting in a hygienic manner with regards to your contracts and your data protection obligations, again, will help the functioning of the organisation. It stops you then coming across a problem further down the line that then takes valuable management time and effort that could potentially take more expense to be tried to deal with further down the line. So it's being proactive and reaping the benefits of it. Now, those are just a few examples. I think there are a lot of little benefits like that that can be picked up. And, you know, let's remember the whole thing with British Cycling. Marginal gains, a number of small gains, add them together, that can lead to an organisation enjoying a significant competitive advantage over its competitors and across a whole sector potentially.
I can't agree with you more. And I think we as employees of organisations as well owe it to our organisation to understand GDPR, understand how it affects our day-to-day work, and understand that knowledge and compliance to the subject provide us some personal benefits as well. You know, there are opportunities to move forward in business because you understand the concept of privacy by design. You understand within a technology department that when you're architecting a solution that we have to think about privacy, we have to think about GDPR, we have to think about right to be forgotten. You know, right to be forgotten is, I think, one of the hardest things that organizations are going to have to deal with, especially when they are dealing with lines and lines of Java code sitting inside a website. They haven't invested in a tag management solution. They haven't invested in the industrialization of data collection. They don't control, manage, and audit the collection of that data. So how on earth are they going to forget a segment of one? So I think there's some personal benefits in there for individuals to move on. I want to do some summarising so that we can really. There's some great questions online that I really want to try and squeeze in at the end, and we've got a few minutes late. Some departing summary terms, some nuggets of thought for people to think of, Peter.
If you go away with nothing else from this webinar, I want 4 words to be at the forefront of your mind. The first 2 are demonstrate compliance. All of this is about being able to demonstrate adequate compliance to the Information Commissioner and any other professional regulator that you might be dealing with who insists on compliance with the GDPR and the EU Data Protection Act. So as long as you can demonstrate compliance, that's what it's all about. All of your compliance compliance has to work towards producing identifiable outcomes, evidence, documentation that you can produce to the regulator, be it documents, be it board minutes, meetings of risk compliance groups, your updated risk register, all the appropriate documentation that allows you to demonstrate you are acting, and these are the next two words, in a proportionate and reasonable manner. So it doesn't have to be the most expensive system. It doesn't have to be going out and having really rigorous, massive plans in place if you're only a small startup organisation. They just want something that is reasonable and proportionate. You have to be able to demonstrate that you've done something. You have to demonstrate that you're thinking about it. You have to show that you are acting in a proportionate manner given the data you have and the resources you have. And as long as you do that, you're going to be about 90% of the way there.
Some questions. I think some of them are for me and some of them are for you. Let's start off with you, Peter.
Okay.
Does this legislation apply to users who perhaps live outside of the European Union, but who are employed by companies within those participating countries? So I guess I'm sitting in the US, I work for Vodafone. Do I have to think about GDPR?
You would, insofar as the organisation you're working with is handling personal data of EU citizens. So in short, the straightforward way of looking at this is that GDPR applies to all of the 600 odd million EU citizens. So if your website or product or service is controlling or processing the data of EU citizens, you have to have a mind to this. So for example, we helped a client last year who they were a Hong Kong registered corporation with a website in Chicago that was with a server in Chicago that was deliberately targeting users in Europe to collect their data. So therefore it had to comply with GDPR as a result, because that data gathering exercise would be continuing throughout 2018. So they had to ensure they were compliant with GDPR.
Peter, that's been incredibly informative. I can't thank you enough for helping us on this webinar. And I think to the people that have attended and appeared here, it's very obvious just from sitting next to him that Peter and Digital Law UK have some very insightful vision into GDPR as a piece of legislation. So I do encourage those members of the webinar community to reach out and speak to Peter and his business. I understand that you can help organizations get to grip with looking at the impact of GDPR on their businesses. You can run assessments on both privacy by design and also impact on GDPR and help people understand how to manage the breach environment. So if anybody is in need of those services, please reach out to the social media addresses that were given at the beginning of the webinar. If people on the call are interested in how technology can help you with GDPR, then we at Telium think that we have a unique position in the world of unifying data within their environment. We believe that the ability to have a hub and spoke environment for data management and the movement of data, private data within an organization, can be used. There are technologies out there that can help. Sadly, there is no easy button. It is a difficult thing. I heard a lawyer tell me the other day that GDPR is like marriage. Do it once, do it properly, or it'll cost you a lot of money. Upon that note, we're going to bring today's webinar to a close. I would like to remind those people who've asked questions on the webinar that we will catch up with them directly and respond to their questions, even though we've run out of time. And I'd like to take this last opportunity to thank Peter for joining us and helping us with what I thought was a really simple and applicable description of GDPR.
Thank you, Lindsay, for the opportunity, and please do feel free to contact me at Digital Law UK on Twitter if you have any questions after this.
Ladies and gentlemen, thank you very much for dialing in, and we look forward to speaking to you again in the near future. Have a great afternoon.